have basically foreseen two essential parts in which my speech is separated. The first part will deal with the separation of powers and tasks between the main actors that we normally refer to as being centralized versus decentralized enforcement of state aid rules. And that involves the European Commission, the national authorities, the union courts, the national courts, and we will, of course, deal briefly with the way in which these centralized and decentralized enforcement actors interact with one another. And we will also consider the available remedies in that context. The second part will be devoted to the Commission procedures, its decision-making powers, and of course, its decisions and the way in which these procedures and decisions interact with particularly national court proceedings and decisions. Okay, then let's move to the first and the most important actor, as I might say, in this area of law, namely the European Commission. It is the main administrative and supervisory body with decision-making power. You could even say monopoly in certain questions. So we were talking about the centralized enforcement and supervision of state aid control. So it is very important to keep in mind that Article 107, paragraph 1, that foresees the prohibition to grant state aid is a very important provision. As a matter of principle, the granting of state aid is prohibited under the treaty. I must confess that one can have a different impression for the time being when you look at the hundreds of millions of euros that are spent by national governments during the COVID-19 crisis in order to support the economy. But this is really a distorting, how to say, impression. It is, still as a matter of principle, prohibited. The Commission has the possibility and the exclusive power to adopt compatibility decisions under Article 107, paragraphs 2 and 3, and also 106, 2 and 3. So this is an exclusive power that, in particular, the national authorities or courts do not enjoy. The procedure before the European Commission is essentially regulated in Article 108, paragraphs 1 to 3 of the treaty, and we have got a procedural regulation that sets out the basic criteria governing these procedures, and it is in essence two-phased: a bilateral administrative procedure running between the Commission on the one hand and the member state authorities on the other hand. So you already see from this that the individual parties, third parties like aid recipients or competitors, are not part of that bilateral administrative procedure. So last but not least, there is Article 108, paragraph 4 and 109 that regulates the regulatory powers of the European Commission. And you will see that the Commission not only enacts secondary legislation such as regulations, but also a number of soft law documents we will have a look at further on. Okay, next slide. Very important to keep in mind is that the Commission decisions are addressed to the member states only. This is, of course, also a result of this bilateral nature of the administrative procedure. The member states are the sole addressees of Commission decisions, not aid beneficiaries or complainants or competitors of the aid beneficiary. We find in Article 4 of the Procedural Regulation 2015-1589 a number of decisions we will have a further look at later on, so-called no aid decisions, so in a case the Commission does not find an aid. Second, the decision not to raise objections because the measure is in its eyes compatible with the single market, or the decision to initiate the formal investigation procedure in order to allow the Commission to make a more in-depth investigation of the case. Secondly, we got also decisions at the end of the formal investigation procedure under Article 9 of the regulation, positive, possibly conditional decisions or negative decisions that can also order the recovery of illegally granted aid. Okay, the very important block exemption regulations are a matter of concern in recent times. We will have a further look at this. The Commission is enabled under the empowerment foreseen in Article 109 in combination with Article 1084 to enact block exemption regulations. This means secondary legislation that is directly applicable in the member states' jurisdictions, and the most of these block exemption regulations is the so-called General Block Exemption Regulation, GBER, that we will also have a further look on. What do these exemption regulations basically foresee? They exempt the member state from the duty to notify certain types of aid, individual aid or aid schemes, in respect of certain categories of cases of aid. And the Commission not only enacts secondary legislation, but mostly so-called soft law rules, since it has the sole power to exempt certain types of aid under Article 107, paragraph 2 and 3. It has discretion to do so, and the Commission normally tries to steer and structure ex ante the exercise of its discretion in individual cases by enacting such soft law rules that includes, for example, notices, communications, guidelines, policy frameworks, etc. In order to show you what the legal and the practical importance of the soft law is, I have just listed on the left-hand side a number of notices that are particularly relevant for our training on state aid litigation. The notice on this notion of state aid of 2016 and a number of procedural notices like the best practices code, the recovery notice, and the way in which the Commission interacts with the national courts is also laid down in a specific notice of 2009. These soft law rules may contain substantive or procedural aspects. They can be horizontal or sector specific and cover, for example, sectors like the energy, transport, rescue, and restructuring aid, or banks, restructuring of banks, for example. What is very important to keep in mind is that these soft law rules, as the word soft already tells you, are not legally binding for the member states' authorities, nor for the union courts, but they have high practical importance. They provide guidance for the practitioner and are an important source of information because they also summarize the relevant case law. But you have to use it with a lot of caution, because sometimes these soft law documents are, so to say, overtaken by the case law and not up to date. In litigation, these soft law rules also play an important role, although they are not legally binding, because according to constant case law, the Commission may not depart from these self-imposed rules without any justification, because otherwise it would run the risk of infringing general principles of law, in particular the principle of equal treatment or the principle of protection of legitimate expectations. This is set out, for example, in the Kotnik case, and it's consistent case law. However, you will notice, if you read some of the general court judgments in particular, dealing with, for example, rescue and restructuring aid or aid for suffering banks, that it looks like as if the court really applies these rules in the sense that they are hard law rules, as if they were hard law rules. This is not true. It is just the way in which the court tries to control whether the Commission has respected its own self-imposed rules, with a view, for example, to the principle of equal treatment. But sometimes it's really hard to distinguish from the application of hard law rules. One very essential document or soft law document that I should also mention is the temporary framework to support the economy in the context of the coronavirus outbreak that is applicable since last year. This already shows the high practical importance of this particular power of the Commission to enact soft law rules. So let's have a look at the member state authorities, so the decentralized aspect of EU state aid law enforcement. So one of the most important duties of the member state authorities is the duty to notify new aid under Article 108, paragraph 3, first subparagraph. Secondly, the member states authorities are obliged to implement the Commission decisions, in particular orders for recovery of unlawful aid vis-à-vis the aid recipients. So we are faced with a so-called double-stage procedure. The Commission will enact a decision that is addressed to the member state, and then in the second step, the member state authorities will have to implement that decision vis-à-vis the individual parties concerned, namely the aid recipients. The third important task of member state authorities is that of implementing the so-called block exemption regulations. These provisions under the block exemption regulations are directly applicable in the member states' jurisdictions. They derogate from the duty to notify aid and therefore simplify for administrative purposes very much the monitoring of state aid. It is part and parcel of the attempt of the European Commission under the state aid modernization to decentralize to a certain extent the application and enforcement of the state aid rules and to, so to say, delegate it to the member state authorities. Although this is a matter of administrative simplification and is designed to relieve the Commission of some of its burden in terms of supervising a state aid, it is very important to keep in mind that this is not an outright delegation of supervisory and decision-making powers from the Commission to the national authorities. That is really important, has been stressed in a number of cases that you will find at the bottom of this slide. I will explain a little bit further on the next slides. Yeah, the first very important and quite recent judgment is the one in AC Pagar, where the Court of Justice stressed the fundamental importance of the duty to notify under Article 108(3)(1) of new aid, even after the enactment of the block exemption regulations. The Court of Justice has made it clear that these conditions under the block exemption regulation provisions are strict, to be interpreted very strictly, because they are an exemption from the general notification duty. Therefore, these conditions need to be very clear and easily enforceable by the member states' authorities. This can cause a problem because I'm not entirely sure, and this is my personal opinion, whether all the conditions set out in the, for example, general block exemption regulations are that clear and allow the member state authorities easily to apply those conditions. I just want to refer to the conditions governing the determination of a small and medium-sized undertaking that has been the subject matter of the Kyrgyzstan case. Next, there is no power on the part of the national authorities to take final decisions on the applicability and the extent to which the notification duty is exempted. So there is no constitutive delegation of decision-making power entrusted to the member state authorities, nor do these provisions and the application of these provisions protect legitimate expectations. Last but not least, it is very important that the member state authorities are empowered to order the recovery of illegally granted state aid because it does not respect the conditions of the block exemption regulations on the sole basis of Article 108, paragraph 3.1. And this is quite new. I just want to recall the very long-standing debate, for example, in Germany, on the question whether a national authority needs to have a known legal basis under national law in order to order the recovery of illegally granted state aid. If that is the case here in the context of the implementation of the block exemption regulations, the court clearly says you don't need a national legal basis and to that effect. It is sufficient to use Article 108.3.1. The court has further clarified this case law in the very important BMW case. This is an appeal case, and it is really interesting to see that the court made here further clarifications in that regard, because this is not normally done in appeal cases, rather in preliminary ruling cases. The Court of Justice stressed once more that the Commission decision-making powers get not lost when it enacts block exemption regulations. It's merely an ex-ante exercise of its discretionary powers according to 107 paragraph 3, so quite similar to the exercise of its powers when it enacts soft law rules. So that means the Commission keeps its overall monitoring function, also with respect to the implementation of the block exemption regulation by the national authorities. It's the ultimate supervisory body also in that regard, which again shows that there is no delegation of tasks and decision-making powers to the national authorities. Although the primary duty to examine the conditions under the BER lies with the national authorities. On the other hand, the exemption from the notification duty requires the conclusion that the BER conditions are actually fulfilled. And if they are not fulfilled and the national authority nevertheless tells the aid recipient or the granting authority that this is an order, then this is illegal, and the risk of the erroneous assessment lies with the national authority and the potential aid recipient. So no protection of legitimate expectations. The court stressed once more that the Commission's supervisory power is not weakened, and it requires the Commission to supervise the observance of the BER conditions on its own initiative or upon complaint. And a very important complaint case has recently been decided by the General Court in the Kirkesand case, where the court stated that the Commission cannot avoid inquiring diligently a complaint that alleges a violation of the BER provisions by the national authorities. And in the case of doubt or serious difficulties, the Commission must open the formal investigation procedure. Furthermore, the court established and recognized that the Commission has to take a decision to raise no objections, not to open the formal investigation procedure when it comes to the conclusion that the conditions of the BER are fulfilled. So that means the complainant can challenge this decision before the General Court. This is something that you will discuss further with my colleagues further on. So the conclusion from all this is that the state aid modernization with the general block exemption regulation has not necessarily brought about more legal certainty, in particular in cases where it is not easy to apply the BER conditions by the national authorities. Moreover, the Commission will have to handle with more care complaints that allege breaches of the BER, and it will have to review that type of handling of complaints in the future, in my opinion. So the bad message to national enforcers is that they have to assume the risk of applying illegally or wrongly the BER conditions, and that they will possibly be corrected either by the Commission itself or by the national courts in that respect. Okay, then let's come to the union courts. The centralized judicial review of legality of Commission decisions, which is a constitutional requirement under Article 19, paragraph 1 of the Treaty on European Union, and under the principle of effective judicial protection, Article 47 of the Charter of Protection of Fundamental Rights. We have two union courts, the General Court as Defense First Instance Court and the Court of Justice as the Appeal Court, which is also in charge of dealing with preliminary rulings. So that concerns the decentralized enforcement aspect. So in centralized judicial review, there is a specific separation of powers and tasks that the General Court deals with the most important action, namely the action for annulment under Article 263 that you will discuss further on with my fellow speakers after that speech. And we can say that the General Court is a first instance EU administrative court dealing with all legal actions brought against individual measures taken by the Commission and other institutions in that field. Another not that much important action is the action for failure to act under Article 265. It's mainly a toothless, could say, remedy in the hands of complainants if the Commission does not wish to act upon complaint, and it is sufficient for the Commission to take a preliminary review on the complaint in order for this action to lose its object and that it becomes ineffective. Against General Court decisions, there is the possibility to lodge an appeal before the Court of Justice that is limited to points of law. Yes, then let's come to the member state administrative and civil law courts, the decentralized judicial review and enforcement in state aid law. The member state courts, in particular the administrative courts, of course, review the legality of national authorities' measures designed to implement EU state aid law, including the block exemption regulation provisions. And a very important power entrusted to the member state courts, in this case also the civil law courts, is the standstill obligation under Article 108, paragraph 3, third sentence. What does this mean? It is the duty of the member state not to implement state aid before the Commission has stated in a final decision that this is either not stated or that it is allowed or exempted under the relevant provisions under Article 107, paragraph 2 or 3. So the primary duty of the member state authorities is to notify new aid and in parallel to stand still, not to implement this new aid until such time that the Commission takes a positive decision on that measure. The standstill obligation is a very forceful weapon in the hands of individual litigants, in particular competitors, that do not want to see state aid to one of their competitors, the state aid recipient. And they can bring action on the basis of the standstill obligation before national courts, because the standstill obligation is horizontally directly effective. That means within the relationships between individuals, and civil law courts have the obligation to enforce the standstill obligation. That means they will also have to apply the notion of state aid under Article 107, paragraph 1. That needs to be read in conjunction with the standstill obligation. However, as we have already said, they are not allowed to apply the exemption conditions under Article 107, paragraph 2 or 3, for which the Commission has the sole power, the exclusive power to adopt decisions. So, what can the member states' courts do? They can suspend the payment of aid. They can provisionally order the recovery of aid, including the payment of interest. And very importantly, they can award damages to, for example, a competitor that has suffered harm because of the granting of the aid to one of its competitors in the relevant market. This has been spelled out lastly in the Fallimento Traghetti case and is constant case law of the Court of Justice. You will have a specific speech on this particular case law later on. What is also very important to know is that in Eesti Pagar, the Court of Justice for the very first time stated that these powers basically apply by analogy to national authorities. That means if national authorities realize that some aid has been granted in breach of the BER provisions, they are also allowed to suspend the payment, to provisionally recover the aid, and so on. Of course, they cannot award damages. This is the sole power of the courts. So you see, not only the administrative, but also the civil law courts are a very important part of this overall enforcement system on the basis of the standstill obligation. And the Court of Justice in consistent case law has granted this standstill obligation with particular, strength in terms of primacy and effectiveness. This is the next slide that shows you how far this can go. Namely, it can lead to a partial transformation or even supersession of the national rules of procedure that govern national authorities or courts' actions. And therefore limit the principle of national procedure autonomy that can lead so far as to reverse res judicata, the definitive nature of national courts' judgments that conflict with Commission decisions, like in the case Lucchini, and lastly, quite recently, in the Buono Tourist case. I really recommend reading this, in particular the part of the Buono Tourist case that clearly shows that the Commission decisions prevail even over national court decisions that have become definitive, are no longer challengeable in the national jurisdictions. So the last cornerstone or pillar of this decentralized enforcement system, in order to make it complete, is the dialogue that the national courts can engage with the Court of Justice under Article 267 of the treaty. The Court of Justice having jurisdiction to give preliminary rulings, either on the interpretation of EU state aid law, in particular the notion of aid, as we have seen the member states' courts are also supposed to apply the notion of state aid in combination with the standstill obligation. So very important help granted to the national enforcers, the courts, in interpreting the different criteria under the state aid notion. And secondly, the Court of Justice may also review the validity of Commission decisions upon request on the part of such a national court. However, this is not unlimited, and this is a very important line of case law that we have to look at a bit closer. Namely, since Textilwerke Deggendorf, the Court of Justice rules that in certain situations, it may not look at the validity of the Commission decision, and the review of validity is foreclosed in the context of a preliminary reference procedure and will be rejected as inadmissible. The last very important case in that regard is Georgs Marienhütte, we will have a further look at. But just to summarize once more the complete or allegedly complete centralized and decentralized enforcement system, this little chart or picture that shows you how the various actors are interacting in that regard. How does review and enforcement run in this system? This, of course, does not involve here the standstill obligation and the powers of the civil law courts. It is more related to administrative litigation. So what does the Commission do? Here I'm pointing to the Commission. It enacts a decision that will be addressed to the member state authorities, stating that certain aid was granted illegally. The member state, in turn, will adopt a decision that will be addressed to the aid beneficiary and possibly also ask for the recovery of the aid. So you see this double-stage procedure. The member state being the sole addressee of the Commission decision and the beneficiary of aid, only the indirect, so to say, addressee of that decision. The decision of the Commission needs to be implemented by the member state authorities. What can the beneficiary then do if it is not, does not like this recovery decision, because it doesn't want to repay the aid that has been granted? It can, of course, bring an action if it is directly and individually concerned under Article 263, fourth paragraph. That is something you will look at with my colleague Kasher in a while, can bring that action before the General Court. If that action is admissible, then the court will give a ruling also on the substance of the case, and then ultimately the Court of Justice will deal with the case upon appeal as the last instance, the final arbiter in this case. The same holds true if the beneficiary brings an action before the national court against the national implementing decision enacted by the national authority for recovery of aid, for example. Then the national court, normally, if it is has problems with the interpretation of EU state aid law and the state aid notion, or even thinks that the Commission decision that is the legal basis of the national authority's decision is not in line with Article 107, then it can ask the European Court of Justice for a review of validity of that Commission decision. So you see a binary possibility of bringing an action against the Commission decision, once directly before the General Court, and secondly, indirectly before the Court of Justice via the 267 review of validity in the context of a preliminary reference procedure. Now the Court of Justice stated something very important in Textilwerke Deggendorf that it has repeated in Georgs Marienhütte. If the beneficiary is not well advised by its lawyers, then it lets expire the time limit for bringing an action under Article 263, sixth paragraph against the Commission decision. It doesn't bring an action in due time before the General Court, but nevertheless pushes the national court to ask the European Court of Justice for a validity review. In that case, the Court of Justice constantly states that you cannot circumvent the definitive nature of the Commission decision upon expiry of this time limit. This has become definitive, and the beneficiary of the aid, if it is undoubtedly entitled, has standing to challenge that decision before the General Court, will be foreclosed from bringing such a validity review request before the European Court of Justice. Quite importantly, that does not seem to apply to actions brought against so-called opening decisions of the European Commission, decisions that merely open the formal investigation procedure. This is something that you can find in Deutsche Lufthansa, and you will possibly discuss further with my colleagues. So I think that was a good summary of the way in which the various players interact in this field of law. Just a few words once more on the Georgs Marienhütte case, which has basically carved in stone this Textilwerke Deggendorf line of rulings, meaning that the definitive nature of the Commission decision may not be circumvented if the applicant has undoubtedly standing to seek the annulment of that decision before the General Court. And the Court of Justice also says that the action for annulment is the more adequate type of remedy to be brought in such a case, because the General Court, can hear complex cases, is the factual administrative court, and this is not necessarily the case for the Court of Justice in preliminary review, reference review cases. And the question still remains open whether the General Court and Court of Justice proceedings can be conducted in parallel. There is some doubt, but in case we have a double procedure running before the General Court and the Court of Justice, the General Court proceedings will always take precedence, and it is also up to the Court of Justice then to stay proceedings and to await the outcome of the final decision of the General Court, which allows the Court of Justice then to combine its appeal function with that of the under the preliminary reference power. Okay, then let's move quickly to the Commission procedures and decisions. The European Commission administrative procedures are basically to be distinguished between 2 or 3 phases. Quite recently, in the Best Practices Code, the Commission has added a so-called pre-notification phase. In most complex cases, the member states wish to engage a dialogue with the Commission services much earlier than the notification, because the preliminary investigation procedure of new aid, for example, under Article 4 is limited in time, namely 2 months. The Commission, upon that preliminary investigation procedure, has several possibilities, either to adopt a no-aid decision if it is of the opinion that the requirements of Article 107, paragraph 1, no aid, are not fulfilled. Third paragraph may decide not to raise objections because it thinks that there is aid, but it is compatible with the single market. On the other hand, if it has doubts or serious difficulties in finding whether this is compatible or incompatible, then it will initiate the formal investigation procedure and invite third parties to submit comments. That is the so-called opening decision. And I just want to recall the Lufthansa case on the previous slides, that this opening decision will also have some legally binding effect for the national courts. We'll come back to this later on. If the Commission does not come to a conclusion within the 2 months time limit, then there is a legal fiction of authorization of aid, and the member states may implement the measure in question, because then the standstill obligation no longer applies. The formal investigation procedure upon opening decision can lead to also a no-aid decision, a positive compatibility decision, a conditional positive decision, for example, with commitments, or a negative prohibition recovery decision. Another type of procedure that is very important in practice is the complaint procedure. And it has been basically the result of the case law that the complainant nowadays has the right to trigger the preliminary investigation procedure and to obtain a challengeable decision that will be addressed to the member states. But in that case, the complainant normally will be directly and individually concerned and can bring an action against such a decision. This has been clarified in a number of cases set out here. I cannot discuss in more detail because that would be a separate presentation. Then we've got a number of special procedures on existing aid and misuse of aid. I don't want to dwell on the possibility for the Commission to conduct sector inquiries, investigation into sectors of the economy and into aid instruments, and a number of provisions that set out the way in which the Commission has to make its decisions transparent inter alia by publishing them in the official journal or on the internet. That can also create some problems in terms of judicial review, because in particular the decisions adopted upon the end of the preliminary investigation procedure are not necessarily published in full. Then, very important, if you remember, the member state as the sole addressee of the Commission decision is the only, basically, partner of the administrative procedure vis-à-vis the Commission, and it enjoys full rights of the defense. Third parties do not enjoy rights of the defense. They are not, have no particular procedural status in this bilateral adversarial procedure between the member state and the Commission, and only limited participation rights. And these interested parties not only include the aid beneficiary, but also, for example, the infra-state entities that basically could grant the aid in question, competitors and trade association. They are merely considered to be information resources by the European Commission. They do not enjoy any participation rights in the preliminary investigation phase. And if you are not a complainant having submitted a complaint, you will not have the possibility to engage into a dialogue with the European Commission. They only have limited participation rights in the formal investigation procedure. But on the other hand, they are submitted to some kind of cooperation duties according to the revised procedural regulation that is also subject to sanctions that you will find in Article 7 of the regulation. However, as you have seen, the case law is responsible for having improved the status of complainants in that regard. Yes, as to the scope of access to justice, I will be very brief. This is something that, in particular, my fellow speaker, Kasia, will address in a while. The member state, as being the sole addressee of the Commission decision, is, of course, a privileged applicant within the meaning of Article 263, while interested parties have to show direct and individual concern under Article 263, fourth paragraph, unless the contested decision is a regulatory act within the meaning of the last limb. This is a new aspect that has been introduced by the Lisbon Treaty in 2009. Possibly Kasia will also talk about this case law in more detail. All in all, we can say there is somewhat inconsistent case law, not only before the General Court, but also before the Court of Justice, I would say, and there are many, many problems of admissibility in that regard. And that also shows that it is not always clear whether an individual party, for example, a recipient, in particular in case of granting aid under a state aid scheme, which is of general application, has always standing to bring an action against such a Commission decision. So you remember in case of Georgs Marienhütte, the individual applicant needs to have standing undoubtedly, and this is not really always the case and creates some problems in legal practice. Okay, then let's come to the final slides, basically, in order to conclude on the interaction between the Commission decision-making procedures and its decisions and the national court enforcement in the area of EU state aid control. Just to recall, the national courts, in particular the civil law courts, enforce the standstill obligation on Article 108, paragraph 3.3. That grants subjective rights, in particular to competitors, to bring an action before those courts, and the courts are obliged to safeguard these rights and to ask, for example, for recovery or repayment of interest in case aid has been granted in disregard of the standstill obligation and the notification duty. Secondly, the Commission decisions need to be protected in case of preliminary requests for validity review before the Court of Justice, in case the applicant would have had standing to bring a direct action under Article 263 before the General Court. That is the Textilwerk Deggendorf line of case law and Georgs Marienhütte. There is a legally binding nature of the opening decisions of the Commission, so the national courts may not depart from the contents, the envisaged decision by the Commission when it opens the formal investigation procedure and envisages taking a final negative decision. Then normally the courts will have to stay proceedings and to await the outcome of the Commission investigation procedure. So in case of parallel proceedings before the European Commission and the national courts, which is always possible. Final decisions of the European Commission always take precedence. That is the Lucchini case and the Buono Tourist case. That means a court may never ever adopt a decision which runs counter to the contents of a final decision taken by the European Commission. However, what happens in case the Commission procedure that runs in parallel to a national court procedure, or in case of subsequent proceedings, is a positive one? The Commission finally concludes that the aid that was granted is compatible with the single market. In parallel, the member states had not notified that aid to the European Commission in due course and had implemented it. That means it has granted the aid before the Commission came to this final positive conclusion. What now? What does the member state court have to do? Does it have to order the recovery of the whole aid, or just what? In order to implement the standstill obligation and to draw all the necessary conclusions from that violation of the standstill obligation on the part of the member states in order to protect the individual rights of the competitors having brought that action. This has been clarified in the Self case of 2008 and has been restated by the court forcefully quite recently in the Viasat Broadcasting UK case. So what are the guiding principles and the basic tensions in that case law? Of course, the member state should not be enabled to take advantage from its own illegal behavior. There can be no favorable outcome of the non-observance of Article 108.3.3, the standstill obligation. Its effectiveness, its effet utile must be guaranteed under all circumstances. So we cannot allow the member states to infringe that rule. And there should be no incentive for the member states to do so, not to notify aid and to implement unnotified aid. This non-compliance should not be rewarded. On the other hand, the national courts needs to draw all the necessary conclusions from the illegal grant of the aid under the standstill obligation, which is directly effective, and has to order the suspension or the recovery of the aid. However, in that case, full recovery is also likely to conflict with a final positive decision states that the aid recipient is entitled to keep the amount awarded illegally. So, and the national court is also bound to respect that final decision. So the court found a compromise solution. One should deprive the aid recipient of the advantage that it had enjoyed during the time in which it enjoyed the early granting of the aid and the adoption of the final positive decision. That means the time span during which the standstill obligation applies and the granting of the aid was illegal. That means, in practice, the court will have to order the recovery of the interests that the aid recipient would have had to pay under market conditions for a loan of the same amount that corresponds to the sums enjoyed. These are the so-called self-interests that the court needs to recover from the aid recipient, while the aid recipient may keep the full amount of the principal amount of the aid granted. In parallel, of course, that needs to be added, there can still be the need to award damages to a competitor bringing an action before the civil law court if it has suffered loss because of that early grant of the aid. And this is not foreclosed by that case law. Okay, I think this is enough for the time being. I thank you very much for your attention. I'm very much looking forward to any questions.